Hi, everyone. Good morning. This is Neil Gonaguntla from the U.S.-India Chamber of Commerce. We are honored that you have joined us this morning for a webinar on wills, trusts, and estates hosted by the Patel Law Group. As you may be aware, this is a 3-hour webinar. This 1-hour segment will be followed by 2 additional segments. The next segment, starting at 11, will be on real estate related concerns around COVID-19. And then the last segment at noon will be on the Paycheck Protection Program and the EIDL program, the Economic Injury Disaster Assistance Program. So you can stay on with us for all 3 hours or come and go as you need to, but we are here to help provide you with as much information as we can to help you and your business during COVID-19. Joining us today for the first segment, we have Anish Patel from the Patel Law Group. I will be providing you with a brief introduction about him, but before I do that, I wanted to share a few different items. Number one, we have a Q&A box at the bottom of your Zoom screen. If you have any questions for Anish during this presentation or for any of our presenters throughout the day, please do not hesitate to go ahead and type those questions in. Anish has very generously offered to field questions throughout the program, so you can type questions into that Q&A box. You are all muted for the purposes of just trying to keep things flowing smoothly, but you can go ahead and type those questions in into the Q&A box if you have any. Additionally, today's webinar is going to be recorded. And as you may know, all of our recordings have been posted to the Chamber's YouTube channel. The Chamber's YouTube channel can be found at USICOC DFW on the YouTube page. We do have all of these webinars named and listed out so that you can go back and access them if you need to. And finally, I just wanted to share a little bit about our upcoming programs. Today, as you know, we have a 3-hour session by the Patel Law Group. On Monday, we're going to be going over immigration-related legal concerns. Ann Badness with Badness Law is going to be talking about implications from COVID-19 on immigration status and the various deadlines and changes that may or may not be coming down. So that's something that you may want to tune into if immigration is something that's been on your mind. On Wednesday, we are delighted to be featuring Senator Cornyn for a town hall at 10 a.m. He will be fielding questions from our membership on a variety of topics that are related to the recent laws that have passed, and he'll also give us some insight into what Congress is contemplating down the road in terms of additional relief and or plans for reopening. So that's something you'll want to tune into. And then next Friday, we are hoping to host Congressman Colin Allred, as well as the Consul General of India, both of whom will be talking about 2 different aspects of COVID-19. Colin Allred will be fielding his business resource guide information and also connecting our members with resources in the community that can help to address various aspects of business relief. And then the Consul General will be joining us as well to field any questions members may have about immigration, or not immigration status, I'm sorry, visitation to India, or Indian nationals living here who may be or who are visiting here who may be stuck here as a result of COVID-19. So make sure you join us for any and all of those webinars or town halls that you think are important to you or your business. And with that, we will get started. Today's webinar is, again, we're delighted to be hosting the Patel Law Group. The Patel Law Group is a full-service law firm and a Fidelity National Title Fee Office. They are a chamber member and have been taking care of our businesses for a number of years now. They're a well-established firm. Anish Patel, who's joining us today, is one of the managing partners there. He, like I, attended Baylor Law School, and so I'm always delighted to host a fellow Baylor lawyer. Anish concentrated his studies in the area of business transactions and estate planning. He comes from a family of hotel owners and realized that this was really an underserved community, and also that legal matters were not really well understood by the Indian American community at that time. So as a result, Anish focused his practice area on business and real estate transactions, as well as estate planning, and that includes wills and trusts and things like that. He also has spent a lot of time supporting the Indian American community, and we're really thankful for that, Anish, that you and your firm have spent some time in the community and supported the community on various legal situations. So without too much further ado, I'd like to hand it over to you, Anish, with one disclaimer to all of our attendees. We want to make sure that you understand that none of the information provided today should be taken as legal advice. We encourage you to use the information provided today to guide your understanding of various legal transactions and situations, and use the information to prepare yourself for meetings with an attorney or with your financial advisors, and not act upon the information that is being provided today. So with that, I'm sure Anish should be happy to take you on as a client and support your needs. But I encourage you not to act upon the advice, but instead to use it to guide your decision making. So with that, Anish, it's all yours. And again, you can type your questions into the Q&A box at the bottom, and Anish will field those throughout the program. Thank you.
Thank you, Neil. Thank you for the introduction. Good morning, everyone. Again, my name is Anish Patel, and I'm here to speak to you about wills and estate plans and why you should consider a wills and estate plan. When I graduated from law school and I got into law, one of my big focus at that point was wills and estate plan, or my primary focus was wills and estate plan. And the big reason why was because I knew in our community there was a huge lack of planning for estates. Biggest culprit I know was my dad. My dad didn't have a will, or he had a very simple will that he just didn't really pay attention to when he created his estate. And the other thing I know is just that, in our community, there is a lot of businesses and wealth that just hasn't really been addressed in estate planning. However, one of the things I also learned real quick was being an estate planning attorney, you're not the most popular guy in the firm. People are coming in more for business transactions, real estate transactions, and estate planning is the last thing people want to speak to. Unfortunately, we're in a very different circumstance right now, and while there's nothing good about the circumstances we're in, one of the good things I can say is that now people are starting to think about wills and estate plans, and it's important because they're very important documents. And I've gotten fielding more phone calls about wills and estates than I have about real estate and business transaction. So to get started here, again, I'm here to talk about wills and estate plan, wills and an estate plan, and how a good estate plan will protect you and your family. Now, a estate plan is more than just a will. An estate plan is there to protect you and your family and your wealth while you're alive, after you pass, and also from taxes. Now, the thing that most people probably skip over is when they're thinking about wills, they're not thinking about how a good estate plan protects them while you're alive. A good estate plan protects you while you're alive with 3 essential documents. It's the medical power of attorney, the durable power of attorney, and a living will. A durable power of attorney is the document that allows you to name an individual to make decisions on your behalf if you're unable to make the decision yourself. And I'm not talking about in the case of your passing, but God forbid something happens and you're in a car accident, you're in a coma. The durable power of attorney allows you to appoint an individual to, if you're in that situation, to go get a check from the bank and make your mortgage payment, or pay your hospital bills, or if there's a business transaction that was going on, that to take care of that business transaction for you and run your business, while you're alive, but you're unable to make the decision yourself. A lot of people believe that your spouse automatically has that right, but they don't. And so in a lot of cases, your spouse would actually have to approach the court and be appointed as guardian to make any decisions on your behalf. So they can't say, a spouse cannot automatically sign on your behalf. They would have to be appointed your guardian to do that. And a simple durable power of attorney can take care of that. Durable power of attorneys can be what is called and I said durable, but it's either can be a durable power of attorney or a springing power of attorney. The difference between the two is a durable power of attorney goes in effect the day you sign it. So the day you sign it and you appoint an agent, let's say you appoint your wife as your power of attorney. Well, whether you're incapacitated or you're unavailable or not, your spouse can use that power of attorney right then and there, and they don't have to prove whether you're unavailable or not. A springing power of attorney doesn't go into effect until, basically the person that you appoint as agent proves that you're unavailable or unable to make the decision yourself. So typically most people have what is called a durable power of attorney, and they typically appoint their spouses as their durable power of attorney. It's been very effective and is very useful in our community, especially because a lot of our family members may go to India for a long span of time. And so I've realized from, as a law practice and on our title side, that sometimes individuals, spouses will go to India and they're selling a real estate, or they're buying a business, or they're selling their business, and they didn't realize that their spouse has to sign off on some of the documents. Well, when you have a durable power of attorney, the other spouse can utilize that durable power of attorney to sign on that spouse's behalf and take care of the transaction. So it's not just if you're in a coma or anything like that. It can also be used if you're unavailable, you're out of the country as well. Now, with a durable power of attorney or a power of attorney, the only decisions that can be made are non-medical decisions. So all medical decisions are administered or addressed by your medical power of attorney. Now, the next power of attorney we're talking about is your medical power of attorney. And again, the medical power of attorney has been specifically carved out by our laws that you have to have a separate power of attorney just for medical purposes. The medical power of attorney, again, if you're unable to make a medical decision on your behalf, then it allows you to appoint an individual to make those decisions for you. Now, in the case of a medical power of attorney, most hospitals will defer to a spouse on the decisions under a medical power of attorney. However, if that spouse were ever to get challenged either by children or by that individual's parents, then the hospital is going to tell those individuals to go to court and to have a guardian appointed to make those medical decisions, because if there's a potential conflict, they're not going to defer to the spouse. This is why it's always a good idea to have a medical power of attorney in place, even if it is your intent for your spouse to make the decisions for you. The last document that's important from an estate plan perspective while you're alive is your living will. Your living will allows you to make the decision today that if you're in a certain situation where, if you're in a situation where a doctor has basically decided that you're going to be living off a ventilator and that you're not going to have brain activity again, then at that point, the doctors will normally go back to the family and say, okay, well, what do you want to do? Do you want to continue life support? Do you want to stop life support? Or is there a living will in place? And what the living will does is allows you to decide today, hey, I don't want to burden my family in the future with that decision. Or if that decision comes up, I want this individual to make that decision for me to continue or discontinue life support. This is important. I don't know if many of you have heard of the Terry Schiavo case, but the Terry Schiavo case, it's almost been 10 years now, but Terry Schiavo was in a coma. She was brain dead. And, her husband wanted to, stop the ventilator and let her pass naturally. And her parents wanted to continue. And so what ended up happening was there was a 4-year lawsuit between the parent and the spouse. And she was on a ventilator for 4 years because she didn't have a living will in place to say, either let me go or to let this individual make that decision to continue or discontinue life support. So after 4 years and almost $300,000 in court and legal fees, the court decided to follow the husband's wishes and allow her to, let her go. Now, the thing with a power of attorney is a lot of people don't want to think about power of attorney, or they think, okay, well, my family will figure it out. The problem is the idea is not to not allow your family to deal with that situation in the first place. It's there to protect your family. It's there to say, okay, because the first question everybody's going to ask if this situation ever came up is, what would you want done? And that's always a question. Whenever in all my years of doing estate plans and estate administration, if this situation comes up, the question always is, what would you want done? A power of attorney allows those individuals to know and have the peace of knowing that you wanted this individual to make the decision, or you wanted to, turn off the ventilator and go. It allows any second guessing of what your intentions are, and which allows harmony in the family. So that's why it's always really important to have a power of attorney in place. So there's no second guessing of what your intent was. The next important document in a good estate plan is your wills. Your wills, the importance of your wills is to, or the purpose of your wills is to basically state to the courts, state to everyone where you want your assets to go to, and who you want to transfer, who you want to appoint to handle that, to handle transferring of the assets from your name into your beneficiaries' names. A third perspective, or third important part of a will, is also to name the guardian of your children. So if a will is important there for those purposes. However, if you don't have a will, the state of Texas has a will for you. And a lot of times, the state of Texas will, or what they call intestate succession, typically follows the succession of inheritance that people in our community would want. The state of Texas, the will for the state of Texas basically provides that if something happens to you, then everything goes to your spouse. If there's no children outside of that marriage, if something happens to both of you, then everything goes to the children. Now, if the state of Texas has a will for you, then why do you need a will? And the main reason why you should have a will is because even though the state of Texas has a will for you, administering an estate without a will is much more difficult than administering an estate that has a will. When you don't have a will in place and you try to administer a estate, you have to bring witnesses in to one testify. Okay, this is the individual that deceased. This is his family. These are his children. There's no other children out there. The other thing is, whenever you administer a estate that doesn't have a will, the courts will typically appoint another attorney to represent any beneficiaries out there that are not made aware of by the court. These are all additional costs that are incurred by the estate in the administration of the estate. When you have a will in place, the courts go by your will. They don't care who else is out there. They don't care what else is going on out there. Who you name in your wills are the individuals that will be the beneficiary of your estate. It will be the individuals that will be appointed as executors of your estate. That's why the will is much more, that's why it's very important to have a will in place, even if the state of Texas has a will for you. It just creates it makes the process a lot easier, a lot smoother, and a lot more cost efficient. For us alone, we charge $1,700 to probate an estate with a will. With court fees and everything, you're looking at about $2,000. But if you're having an estate that has no will, you're looking at maybe $2,400 from legal fees, and then maybe another $600 in just court fees. Because remember that you have to hire another attorney to administer. They have to hire another attorney to make sure there's no other beneficiaries out there that are not being represented. Which is why it's important to have this will. Now, unfortunately, only 30% of individuals have wills in place. There's 70% don't. Now, the important thing to understand from a wills perspective is that we live in a community property state. And so what that means is this whole idea that, okay, well, everything's in my name already, so I don't need to worry if something happens to my spouse or vice versa. Well, in a community property state, everything is owned 50-50. So whether everything is in your name or not, 50% of those assets is owned by the other spouse. And if you don't have a will in place or that spouse doesn't have a will in place, then those assets don't automatically come into your name. Again, an estate administration would have to occur. Again, 2 witnesses would have to come in, and then if everything goes by the the Texas will, which is there's no other spouses, no other children involved, then everything would come to you. However, the smarter and more efficient way to handle this is to have a will in place. I'm just going to take a minute. Are there any questions at this point? Okay.
We don't have any questions yet.
Okay. So the other part, and I would probably say probably the most important reason to have a will is if you have minor children. There are a lot of individuals who have minor children who don't have wills, and if you don't have a will in place, then the courts are the ones that are the individuals that are going to appoint who the guardians of your children will be. And what would happen if something were to happen to you, obviously individuals step up to want to be appointed as guardians, but at the end of the day, that's a decision you should be making, not your courts, not the courts. A lot of estate plans that I do, I start a lot of estate plans. Clients come in and see me for an estate plan, and they go home with the questions I ask them, which is, who do you want to be executor? Who do you want to be guardian? And they'll have answers for everything except for guardian. And a lot of times clients won't even come back to me for a year and a half later, and they'll say, well, we just couldn't figure out who we wanted to appoint as guardian of our children. And my point to them has always been, it's better for you to have guessed on who you want and made that decision now than for some stranger in the future to have, or some judge in the future to have made that decision for you. You know your family, you know your children better than anybody else. So it's a decision you should make, even if you're not 100% sure. You should still try to make that decision as best as possible now, instead of letting someone else make that decision for you.
Anish, we have several questions that have come up.
Sure.
So one of our members is asking, what's the difference between a medical power of attorney and a living will? I know you touched on that. Maybe just a quick high-level difference between the two.
Sure. So a medical power of attorney, a living will is, a lot of people consider that as part of a medical power of attorney, but the medical power of attorney only allows you to appoint an individual to make medical decisions for you if you're unable to make those decisions yourself. Now, the only exception to those medical decisions is a decision to continue or discontinue life support if you're on a ventilator. So the medical power of attorney is basically a broad medical power of attorney to make all medical decisions except for that one specific decision to continue or discontinue life support. That decision is addressed by your living will. And your living will, again, in that situation, you can make one or two decisions. You can decide to say, okay, if I'm on a ventilator, there's no chance of me coming back. I don't want that decision to go to my family. I want you to, stop all treatments and let me go naturally. Or the other decision you can make in your living will is to say, okay, I've named these individuals in my medical power of attorney. I want you to let them decide. I want to let them decide on my decision to continue or discontinue life support. So that's a difference between a medical power of attorney and living will. Living will basically carves out that one decision to continue or discontinue life support as opposed to the medical power of attorney.
Okay, we have another question here.
Okay.
In general, with durable powers of attorney, if there is a real property in another county or state, do we have to record them in each of those applicable counties?
No, you don't. So you don't have, there is no requirement for you to record a durable power of attorney. Now, however, if the concern is that, you know, that someone's trying to sell those properties in the state without you knowing, well, let me go back a sec. If the idea is that you want that person or individual to be able to sell those properties in those other states, then all they have to do is present those documents to the title company or to the real estate agent to have that authority. A recording is not required. And in all honesty, you can actually record all your estate planning documents, but there really is no benefit. Nobody actually goes and searches for wills and power of attorneys in recorded documents. People have done it before, but there really is there's no benefit to it. There's no notice. It's not like, okay, if I record it, this puts the whole world on notice that this person is my agent. Unfortunately, it's not like that.
Then that same individual had another question.
Sure.
This is in context of real estate documents signed pursuant to the power of attorney. So that was a clarification on the other one. Okay.
Yep.
So just going to the next one. How does allowing someone to live in residence until his or her death work?
How does allowing someone to live in his residence until his or her death work? I'm still not kind of understanding the question.
Yeah, let me ask for clarification.
Yeah.
Okay, so next question. Our will is old and needs updating. How much should that cost for us to update it? Do we need to go to the original attorney who created it for us?
It depends. I mean, I would definitely go back to the original attorney. I mean, my clients come back to me. You may not need updating. There's a lot of, so the way a will works is a will, just because the law changes doesn't mean your will becomes outdated. So when a will is probated, and it's probated based on the laws that were applicable at that time. So let's say, for instance, you signed a will back in, 1998, right? And at that time, only, one witness was required. Now, that's never been the case, but I'm just throwing that as an example. Only one witness was required. So you signed the document, you had one person witness the document, and the document was notarized. The courts will still find that document valid, even though now today you have to have two witnesses and a notary to sign a will. Because at the time when you signed the document, it was a valid living document. The same also applies for wills and will documents that are created outside of the state. So there's a lot of, every state has a reciprocity with every other state, and it basically provides that if a will was created in another state while you're a resident of that state, and that will is in compliance with the laws of that state at that time, then the state of Texas will honor it. And again, this is applicable because in some states, not Texas, but in other states, they require three witnesses to sign a will. But if you're a resident of Texas and you had it signed properly with the procedures of Texas or based on Texas applicable law, every other state will
honor that.
Will honor that document, yes.
Yeah. And
vice versa. So say Texas does it as well. So I would go back to the attorney maybe and talk to them, or again, you can come to us as well. We definitely will review the document for you, but the cost all depends on how much the volume of documents we're talking about. But I would go back to your original attorney, and more likely he or she may say that you don't need to. There's nothing you really need to update. The times you need to update it is like if your estate grew grossly and you want to do maybe asset protection, or you have a situation with a child where you want to provide that the money is more protected for the child. But if you just had another child, or now your kids are majority age, more than likely if there's no major change, you may not need any changes at all. But it's always good to. What I always suggest is always good to review your documents You'll be surprised how many times that I create a document, and I've always told my clients, after a year, come back in, let's go over your documents again, see if everything is exactly the way you want it. And they'll come back in and we'll go over who they name as executive of the estate or trustee of the estate, trustee of their trust. And they're like, oh, I named that person, or I named that person as backup. And I'm like, yeah, see right here, here's my notes, you guys named them. And they're like, no, we're going to change that up again. And so it's just funny that within a year, things can change.
We have another question here. If there is a will, is there still a court process to pass on the assets?
So it depends. A will allows for the passing of what are called probate assets. So there are two types of estate assets out there. There are probate assets and non-probate assets. The non-probate assets are anything that has a beneficiary designation or a pay on death designation. So
that would be like a life insurance policy or a bank account. Those are considered non-probate assets because when you open the account, you set up a payable on death beneficiary.
Correct. So one of the big things I always tell my clients is, and we have a will in place and everything, but if you want to make sure there's no problem, there's no interruption of like cash flow or anything like that for your spouse, place a pay on death beneficiary, make your spouse a pay on death beneficiary of your bank account. So what that means is that if something were to happen to you, you pass. When you go to tell the bank that if you're passing, they're not going to lock your account because you've passed. Instead, what they'll do at that point is they'll see who the pay on death beneficiary is. They'll say, okay, it's a spouse, and they'll give the spouse full access to the account. If there is no pay on death beneficiary, then what the bank's going to do is say, okay, well now you need to go get an executor appointed and have them come in and handle the cash in the bank account.
So another question here. We have no children, but we have pets. Can you add a guardian for pets?
I'll be honest with you. I know. Well, I know you cannot add a guardian for a pet, but I haven't really handled pets before. I'll be honest with you. So let me look into that, and I can obviously, if you want to email me, I can always follow up on that question for you.
Sure. And your email address is apatel@patellegal.com.
Correct.
Okay. Does the do not resuscitate also include CPR?
I'm not sure. So do not resuscitate is more of a medical document, and I want to make sure everybody's clear on this. A do not resuscitate is not the same thing as a living will. A living will is a do not resuscitate, and again, I'm going by my brother-in-law who's an ER doc, so we had this discussion before, but that's when they're in the wake of a procedure or they're doing, I'm going to say procedure or trying to, trying to treatment on you to bring you back. That's when a do not resuscitate comes in, right? A living will is more of a situation where you're at peace, but they're trying to decide, okay, are we going to continue medicine? Are we going to continue food? Are we going to continue to extend your life out? So there are two different documents. Unfortunately, I can't really tell you if the do not resuscitate includes CPR or not.
Another question here. If someone dies owing IRS taxes,
okay,
and they have granted a life estate, can the IRS force the sale of the home? I guess they granted the life estate in the home.
If someone dies owing IRS money and they granted a life estate, can IRS force the sale of the home?
And the question is, how does granting a life estate work? This is probably a good question for a property attorney.
No, yeah, well, it's the question of the IRS tax. You can, the way you grant a life estate is basically you create a deed. You deed it from yourself to the individual you're giving a life estate to, with a caveat that's saying, okay, this is for your lifetime, and after you've passed, it goes to this other individual. That's how you create the life estate. If you owe tax and you created this life estate, I guess as long as you do it before they place a lien on your property, you should be able to create the life estate. I'm not sure if there's any other way they can pull it back in, because you are making a transfer when there's a debt out there. It's probably a little bit outside of the scope of this conversation.
Yeah, I would say probably sit down with you guys or with a property attorney.
Yeah.
On that. So next question. We need to change our alternative beneficiaries in case we die at the same time. That would be the update. This was the original question too. Should we go to our original attorney, or can we go to anybody for that?
You can go to, again, you can go to anybody. Now, the one thing I will tell you this, and I with a lot of my clients, and one of the reasons you may want to go to your original attorney is this. I'm not a big fan of codicils and any kind of amendments to trust. Well, amendments to trust I'm okay with. I'm not a big fan of codicils. What is a codicil? A codicil is an amendment to a will. So in this case, you know, you can go to another attorney. The other attorney may say, okay, yeah, definitely we can create an amendment for this will, updating the alternate beneficiaries. The reason why I'm not a big fan of codicils is, and I've personally experienced this, is that a codicil is only effective if people know about the codicil, about the amendment being there. And I've had a situation, it was an estate administration situation, where we started this administration of the estate, and everything's going forward. We had the will and everything, and we have the executor appointed, and almost about 6 months into it, when the kids are cleaning the house, they find the codicil state providing that the current executor is not who the decedent wanted as executor. They appointed somebody else as executor. And so that, my big reason for not wanting codicil or amendments nowadays is that because we have Word, it's easy to update documents. Your original attorney should have the old will document. I think it's just better practice to create a new document and completely get rid of all your old documents, so there's never any misunderstanding. Because if someone finds a will, their tendency is to not look any further for other documents. And if they don't look for that codicil, then it's not being very effective.
Great. So I think we're good for all the questions that we've gotten so far.
Okay.
So let's move on to trusts. I know we don't have a ton of time,
Sure.
but maybe we can just move on to trusts for the next 20 minutes or so. And as I was saying to you beforehand, I think if you're open to it, Anish, we'll do a whole other webinar just on trusts, because I know that's a lengthier conversation. And I know our members will probably have a lot of questions on that. So
Sure.
If that's okay with you, we can continue the conversation again in the future. But for now, let's just kind of do a high-level overview of trusts.
Sure. And so, and kind of going back to the conversation and discussing trust, you know, there are everybody comes to me like, okay, have you heard of this trust? Have you heard of a living trust? Have you heard of a Cupid trust? Have you heard? There's so many different trusts out there. And what essentially a trust is it's not an entity. It's basically you giving someone the authority to hold assets on your behalf and control those assets on your behalf, or sorry, not on your behalf, but control those assets on the behalf of another beneficiary. So it sounds a little bit complicated, but it's at the end of the day, it's saying, okay, let's say it's an inheritance for a child, right? So your inheritance is, the inheritance you're leaving your children is $100,000 each. If you basically have a will that provides that everything's going to go in trust for the benefit of your children, and you appoint, let's say, your brother as trustee, you're basically giving him the $100,000. Now you're giving him the $100,000. So there is a reason why these individuals are called trustee, because you're trusting that this individual will hold that money, manage that money, and do everything in the best interest for the beneficiary while he has that money in his possession. And so it's vitally important that the person you name as trustee is someone, again, that you fully trust, because even though there are checks and balances in place to hold a trustee liable for the beneficiary, sometimes it may be too late until the damage is done before they even find out that trust has been broken. So let me kind of step back a bit. A good reason to have a trust in the first place for a lot of individuals is because they have minor children and there may be substantial assets that this child is going to receive. However, if they're minor or if they're young, they may not be they're not mature enough to control or handle that money. And so what a lot of individuals do, they'll set up trusts for these minor beneficiaries or for their children, So that individual can, control the money, manage the money, distribute the money for the benefit of the beneficiary until that beneficiary may be old enough to handle the money himself, him or herself. Or, if it's someone that you feel is not, savvy enough financially to handle that money, just or if someone that you feel is better at managing funds and growing funds, you may want to just leave it with that trustee because you feel like they're good at growing those funds and managing them. But most of the time, most individuals, when they create a trust, they create it for the benefit of their children. Again, there's a lot of different types of trusts out there. But the two main different types of trusts are what are called revocable trust and irrevocable trust. Back in the days, people were very big on these what are called revocable living trusts, which is really a trust you set up today, and you place your assets into those trusts. So that way, if anything were to happen to you, then those assets, without avoiding probate, would pass to the next generation or pass to the spouse. And a lot of people were doing these because they're afraid of probate, or they didn't think that they thought probate was a long, drawn out process. It's going to cost a lot of money. However, it's actually not that bad, especially here in the state of Texas. The state of Texas is very much of the opinion that if we do an estate administration, you create a will, you appoint the executor of your estate, then if you trust that individual, the courts in the state of Texas trust that individual, and they're going to let them go about administering your estate without much court intervention. Whenever the cost usually goes up whenever you have a lot of court intervention, but the courts in this case, if you appointed an independent executor, they're like, listen, you appoint them, you trust them, we're going to go with it, and we're not going to be involved. What's the disadvantage of having a trust now, a living trust now, and placing all your assets into it? Probably the biggest disadvantage, I say, is the hassle of dealing with it. When you have a trust, you have all your assets in trust. Whenever you go to buy or sell a business, you need to make sure you provide the banks or the title company copies of your trust documents. When you open up a bank account, same thing. You got to have your trust documents. The big thing for me is that whenever you have it during your lifetime, you have to provide your trust document to a lot of individuals, and so the privacy, you lose a lot of the privacy that you would have had if you didn't put assets in it nowadays. The other thing about it is almost every single time when anybody's ever had a living trust in place and they've put assets into it, they've always forgotten one or two assets, and so a probate has had to happen because those one or two assets need to be transferred into the trust. What I always tell my clients is live your life normally. Buy your assets, sell your assets, keep them in your name, and let the will take those assets and put it into trust for you. It provides you no asset protection benefit. It provides you no tax benefit. I know a lot of people out there have the idea that if I create a trust and put my assets in there, it'll be protection from my creditors. It won't. The state of Texas and almost 48 other states all provide that if you take your assets and you put it into trust for your own benefit, it's not protected from your creditors. If that was the case, and most people would go get $1 million loan, guarantee the loan, put the money into trust, and then tell the bank, okay, now you can't touch me. That's why you can't put assets into a trust for your own benefit and protect it from your own creditors. Now, that doesn't mean that you can't do that for your kids, which is why I think probably the biggest opportunity that most individuals miss out there is the opportunity to protect your children's inheritance. So what I always tell my clients is, while a trust may not be beneficial for you, it's hugely beneficial for your kids. You can take that inheritance that you're going to leave for your child and leave it in trust for their benefit. So that way in the future, if they're ever to get, in a car accident, sued or judgment against them, or if they're ever to get divorced, that money is not their money to be taken by their creditors or their spouse, which is a huge benefit that most people don't even think about. And you can also even set it up where it's not just that inheritance, it's that inheritance and, the growth of that inheritance from what, you can take, let's say you have a child and you leave that child $100,000 in cash, right? And that child takes that money and invests in the next Apple stock. Well, if you leave it in a trust and the child invests in that Apple stock through the trust, and it goes from 100,000 to 10 million, well, that full 10 million is still protected. And you can also set up that trust to where it's not just going for the benefit of that child. If that child passes away, then it'll be for the benefit of his children, which would be your grandchildren, and so on. In the state of Texas, you can't have a legacy trust, but there are ways to continue that trust and that legacy without voiding the rules of Texas, the rules of perpetuities in Texas. So my advice to most of my clients is, you should always think about having wills and power of attorneys in place, just as a basic for an estate plan, to make it convenient and easy for your spouse or your children if something were to happen to you. But my second step has always been, you should really always consider doing a trust for the benefit of your children. It's just a huge benefit. I have so many clients who come in that are physicians or are in other high liability situations, or business owners who are always like, okay, I might be coming up with some trouble. What can I do to protect my assets? And while there are a lot of things we can do from an asset protection standpoint to protect those assets for those individuals, there's nothing that's 100%. However, your parents leaving your inheritance in trust for your lifetime during your lifetime can be protected from your creditors and your spouses for that purpose. So my recommendation of my clients always, from an estate planning perspective, is always make sure you have wills in the estate plan. Make sure you have wills and power of attorney in place. But if you have a sizable estate, you may want to consider setting up a trust for the benefit of your kids. So that way their inheritance is protected, and it's always a great little protected nest egg available to them in the future. Are there any questions at this point, or?
Yep, we have one question here.
Okay.
In my trust, if I or we want to give assets to charities, is that handled differently than giving money to children?
So that individual has a trust already?
Yes, they have a trust already.
So if the trust allows for you to make a gift to a charity, it's great. More likely, if it doesn't provide for that in the trust document, then what would have to happen is that person would have to take the money out as a beneficiary and then make the gift to the charity. Does that answer that question? Or?
Yeah, I believe so.
Let's see.
Or can they amend the trust documents, or do they have to revoke the trust and then create a new trust?
So it depends. If the trust is a revocable trust, then it can always be amended. Okay. If it's not a revocable trust, then it cannot be revoked either. So that's a big difference between a revocable trust and an irrevocable trust. The irrevocable trust has a lot of benefits in protecting your assets, or not your assets, but maybe the inheritance for kids. However, it's important to understand that once it goes to the next generation, that trust goes from revocable to irrevocable. So changes cannot be made. There's good and bad to that. I mean, the reason why you set up the trust in the first place with the trustees you want and the beneficiaries you want is because you don't want anybody changing the rules in the future after you pass, right? Which is why it becomes irrevocable, and that can be changed.
Got it. We have another question here. If you have a trust for the benefit of children, you still have to show this document every time you purchase a business or sell a business or property? Yes.
Yeah. So, well, again, when we're talking about if the trust for the benefit of the children owns the asset. So the way we set up wills and trusts for our clients, and my recommendation is usually during your lifetime, you have a will in place, and during your lifetime, you just live life normally. You buy and sell assets, you build your business, you grow your estate as you want, as you normally do, right? But then if something were to happen to you, what happens is that we set up the will where the will provides that 1/2 of your estate automatically goes into the trust for the benefit of the children. Or actually, it goes into a trust for the benefit of the surviving spouse first. And then upon passing of the surviving spouse, everything goes into trust for the benefit of the children. So it's the same trust agreement, but first it's there for the benefit of the surviving spouse, and then upon passing of the surviving spouse, it's there for the benefit of the children. And so while you're alive, you don't need to show the trust to anybody, when you're buying or selling business or real estate. However, in the future, when you and your spouse have both passed, and the individual trustee that's administering the estate or the trust, they would have to show the trust documents when they're buying and selling assets.
Got it.
Yeah.
Yep. Let's continue on.
Okay. The other part. Sorry. Go ahead.
So talk to us a little bit about the difference between a revocable and an irrevocable trust, because those are two terms that you've mentioned.
Okay.
And that may be a little bit confusing for people if you're not a lawyer.
Sure. So a revocable trust is a trust that you create today. And you can, the main difference between a revocable and irrevocable trust is that when you create a revocable trust, you can put assets in that trust, take out assets whenever you want, and change the terms of that trust at any point on a whim. That's a revocable trust. It can be revoked or amended at any point. An irrevocable trust is a trust where you set the trust in place, you name the trustees, the beneficiaries, when money is going to be distributed out, and none of those terms, once you set that trust in place, none of those terms can be changed. So you're setting that in stone. It's a much more permanent, and it's one of those things where I caution my clients all the time. We're doing an irrevocable trust. We need to be 100% sure this is what we want to do, because once we set it up and once we fund it, we can't change it. Most people, for most of my clients, we do what are called revocable trusts now. I don't really get into irrevocable trusts unless we're trying to do estate tax planning or really advanced asset protection planning. Whenever we do irrevocable trusts and we're putting assets into those trusts, we're talking about assets that an individual will never expect to use. So, I mean, their estates are so large that, they're not expecting to use, a quarter of it. So it's a very permanent thing. And the other part to it is that we want to make sure that the individuals they point in those documents are individuals that they want to control those assets. Because when you set up an irrevocable trust, you're typically not the trustee, you're typically not the beneficiary.
So one of the questions that I know I've gotten before is, how big does my estate need to be? How much in assets do I really need to have?
Sure. And I love that question, because I get that question all the time. It all depends on you. All right. I've had clients who've had a $300,000 estate, and whenever I sat there and told them that, listen, when this money goes to your children, it's going to be protected from their creditors and from their spouses. And I think it was the spouse part that really clicked in their head more than anything else. They're like, done, sign me up, right? But then I have clients who have $1 or $2 million estates, and when I've told them the same thing, they're like, no, my estate's not large enough for that. So it really just depends on you, on whether you think it's advantageous to you. Obviously from my perspective, I've seen the other side of it. Whenever clients come running and they're about to get sued, or they're afraid of their assets being taken away. At that point, those individuals are willing to spend any kind of money to protect their assets. And so doing a simple trust for the benefit of your kids, it would seem like chump change. So it just depends on the individual.
How much does it cost to set up a trust?
So, and again, not to avoid the question or anything, but we typically, the starting cost for a trust is around $1,500 for us. But it also depends on, it starts at $1,500 and can go from there. It just kind of depends on how complicated you want to get. I mean, I have individuals that put in specific situations when money is going to be distributed, and then situations they'll put in where, like, if this event occurs, then the new trustee will be appointed. So you can get very, very detailed into a trust and make what they say a lot of times with trust is you're controlling the money from the grave. Or you can keep it very simple and as flexible as possible. So it just depends on what you want in the trust. But typically our trust starting cost on a trust is about $1,500 from our perspective.
Gotcha. Well, Anish, we are right at 10:59. I know we had a few more questions in here, but I think what I will encourage everybody to do is reach out to you directly and see if they can just set up time, become a client, or they can, you know, go to their own attorney to get that question answered.
Sure.
With that, we will go ahead and close. Oh, we have one more question from a member. Can you field one more?
Yeah, sure.
Okay, if I hear you right, what you're saying is there is no need to fund the trust while you are living. Just live your normal life. Wills will automatically fund the trust when you are no more. And that's only if you set up your will to create a trust upon your death. Is that correct?
So two things. Yes, but whenever, and I say two things is we set up our wills to where the wills will distribute the assets to the trust. I'm not a big fan of the wills that have the trust created in the wills. I like to have the wills set up separately because the other thing about it is the other thing about all this is privacy as well. If your trust is created in your will, then your will is recorded and it becomes public documents. So our practice is, and my recommendation is always to keep them separate. The other part is it gets really confusing for your clients whenever they see the wills and the trust and everything in one document. And our practice is always we create a separate will and separate trust document. And then yes, the will automatically transfer those assets into your trust. Now, when I say automatic, it will transfer the probate assets. If you have a life insurance policy or a pay on death account or a retirement account, you need to change the beneficiaries on those accounts to your trust. The will only take care of what are called probate assets.
Got it. All right. Well, thank you so much, Anish.
Yeah.
Again, if anybody would like to get in touch with Anish, you can reach out to him at Patel, APTEL, at Patel Legal, PATELLEGAL.com. And with that, thank you so much, Anish. We'll circle back on the trust. I think we have a lot more questions on trust. And so we'll circle back on that maybe for a later webinar in another week or two, if that's okay with you.
Sure, we'll talk about it.
Great. Thank you so much, Anish. Appreciate it. And joining us now, we have Shamir Soni. Shamir is a business transactions lawyer in the Patel Law Group. And Shamir is also a Baylor lawyer. So again, sick and bears. And Shamir, I'm going to go ahead and let you get started. You're going to be talking about real estate transactions, landlord-tenant issues, forbearance issues, lots of implications for real estate owners and multi-tenant property owners during COVID-19. So I'm going to go ahead and let you take it away. Again, you can post your questions into our question box here. We will continue to field those periodically throughout the program. So with that, Shamir, I'm going to go ahead and let you take it away. Please introduce your fellow panelists there. And
yeah, so hey, thanks, Nalima. And I have with me Jonathan Jascott. Jonathan's a senior associate at our firm. Texas Wesleyan Law? No, SMU Law? Right. SMU Law, ECU.
I guess we'll let him present today. It's okay.
Yeah, exactly. All right, so just to kind of summarize what Jonathan and I are going to talk about. So Jonathan and I run the multifamily side at our firm. So we do multifamily acquisition, disposition, we do refinances, we do what we call syndicated financing, where the equity side of the transaction is raised from a group of investors. We do debt, and Jonathan spent a number of years, and he'll explain, as lenders counsel. So what we want to do today is, I know that we have a lot of folks that are real estate investors, real estate owners that are members of the chamber. And so we wanted to kind of coordinate with them and really circle back on kind of what the key issues are right now in the multifamily, single family rental market, what they've got to be aware of in light of COVID-19, and what that means kind of going forward. So some of this may get a little difficult or a little complex, but a lot of it's very apt based on the current times. And we encourage people to ask questions. I just did one last night like this. It went on for like 2 hours with questions. So we encourage people to ask as many questions as they'd like. As I said, my name's Shamir. I'm a partner at the firm. I run the multifamily practice. I've been practicing primarily multifamily for the last 3 years. I've been an attorney for 12 years through a range of corporate finance positions. We've done deals ranging from hundreds of thousands up to hundreds of millions. We've sold companies to Apple and Intel. We've worked on private equity rounds of financing. We've worked on debt financing. Our firm, as Anish may have mentioned prior, is 13 attorneys, 35 staff, 3 offices across OKC, Houston, and our primary office in Dallas. Transactionally, we have 7 attorneys, 1 in Houston, 1 in OKC, and then 5 of us in Dallas, including Anish and I. Our 2 primary areas of practice are on the transactional side are hospitality or hotels and multifamily. We do ground up, we do acquisition, we do just about everything. So we're truly a full service firm. We have a litigation practice, we have a business immigration practice. We also own our own title company where we close our transactions that our sellers are typically working on. So kind of a true 360 approach around your traditional real estate entrepreneur. And we kind of built it that way on purpose because nobody else was doing it. And we feel like the way we do it is better than anybody else. Jonathan, talk about yourself.
Yeah, and like Shamir said, I work with Shamir directly a lot in the real estate transaction department of our law firm. I was basically brought in about a year ago to really develop more of the multifamily business, work with contracts on multifamily, hotels, vacant land, office buildings, all sorts of different projects. My specialty was kind of reviewing title commitments and obtaining certain endorsements, doing title insurance, surveys, and also doing lender loan documents. So I think that was a big need in this area, and I think basically I came in and kind of restructuring how we do opinion letters and title objection letters to the real estate practice, and making sure everything is in order with a lot of our buyers doing real estate and these complex commercial transactions. I'm able to really explain a lot more and provide that additional time to our clients, specifically the buyers, on what exactly they're getting with title insurance, what are these certain exceptions, what we need to do. So I work a lot closely with a lot of lenders counsel in trying to finish out the borrower's due diligence, specifically legal due diligence process, and make it as smooth and easy for our borrowers as possible.
Yep. Cool. Perfect. All right. So kind of the way we're going to break this down is we're going to talk a little bit about the state of the market, get into kind of what the CARES Act means on the multifamily side and some of the changes that it's triggered, and then talk a little bit more about what we're doing on our deals now that we're in this kind of new reality post COVID-19 and where the new reality of COVID-19 and where we stand with respect to transactions. So so generally, what are we seeing? So multifamily, obviously, when COVID-19 hit earlier, I guess last month now, we had about between 20 and 30 deals kind of in the hopper between things that were under contract, things were about to go under contract. We had accepted offers and we were working through deal docs. As soon as the crisis hit, that dropped pretty precipitously down to about 2 or 3 deals We had a couple of deals close, so I don't think that there's any question that whether deals will close or not. We've had deals close, but I think what's happened is the kind of the terms on which they've closed has changed, and a lot of that's been dictated by lenders. On the multifamily side, we're seeing requirements of higher or lower loan to value, higher reserve requirements on principal and interest, more onerous conditions with respect to coverage ratios. Rates may be favorable, but if you're putting up more money, then you're not really generating a true value from that. So we've seen some of that. We're still seeing deals get done with guys that are like 1031 down leg buyers, out of town buyers, international buyers that are paying cash. So I don't think there's any doubt that transactions can get done. I think it's just a little bit more complex in terms of getting them over the finish line. On the sell, so that's on the buy side. On the sell side, obviously sellers have a lot less leverage than they did pre-COVID-19. So we're seeing pricing obviously drop. We're seeing financing contingencies in the multifamily space, which never existed pre-COVID-19. We're seeing adjustment language, and Jonathan's going to talk about that some more. Price adjustment language based on occupancy. Jonathan will talk about that some more. In terms of the factors, and then on the single family side, what we're seeing is debt's obviously tightened up significantly. Lenders are a lot less apt right now to lend money than they were pre-COVID-19. I think we're getting into kind of a free-for-all, but that's obviously shifted back pretty dramatically right now. So obviously our lenders are a little tighter, our lenders are tighter. Sorry, I gotta get closer. And our tenants, we're seeing more delinquencies, so lenders are obviously more concerned. And then as owners, I think a lot of our clients that were in the single family rental business for a long time are starting to see a level of delinquency or tenant fear that they never saw before, and that's really kind of adjusting their business model and making them make decisions that they probably never had to make before. So we are seeing, we're seeing some challenges and some headwinds in both the single family and the multifamily space. What do we think moving forward and just generally for the market? I think multifamily April rents have now been paid. We expected a pretty significant drop in rental collections just because a lot of people are unemployed right now. We're not getting paid. That wasn't as bad as we thought it would be. Our average what we call economic occupancy or collection rate versus 100% occupied at 100% rent. Our average economic occupancy is about 90% on your traditional day-to-day basis, 92%. Right now, that's probably closer to the high 70s, 76 to 80%. So the drop-off, although it sounds massive, 10 to 14, our properties, most of them still remain solvent and do not require massive infusions of capital from their equity. So that's a good thing. On the single family side, obviously having a property sit empty for any extended period of time is harmful. But I think our clients have been through a pretty good period to where they have reserves in place on the single family side to where they could probably weather the storm. We're anticipating that this will last through June, July, at which point we should return to some degree of normalcy, assuming that there's no second bounce of virus. So, generally we're seeing this more as a shock rather than a systematic failure of the marketplace. It's essentially 3 to 4 really difficult months, and then we'll go back to some degree of normalcy in a market that's now flush with cash after the Fed's pumped in and the Treasury's pumped in, trillions of dollars. So we are set up for a really interesting summer and fall this year, especially going into an election too, in terms of what's going to happen to the real estate market and what's going to happen to a lot of our real estate clients. So what do you think? What have you heard from our folks? What is their opinion?
So I've been kind of working a lot with sellers and buyers in the multifamily space, particularly in the past 2 weeks, and trying to, keep contracts going, amending contracts, and trying to begin new contracts with new clients. It's definitely changed for an environment out there, and unfortunately, I think this is more of a shock factor for a lot of sellers right now, but borrowers and buyers are struggling right now to obtain the acceptable terms that they want for certain loans, and their standards are now going to have to rise because of certain lenders wanting these additional reserves, wanting these additional underwriting requirements. Just in the past 2 weeks with what I've been dealing with the buyers and sellers, I kind of decided to actually put together an article about the certain sort of specific contract issues that keep reappearing with my discussions and what we've been going back and forth with buyers and sellers and trying to obtain a mutually acceptable contract in order to move forward to closing. Like Shamir said, this is a new environment. Terms are changing now. Contingencies are the new rave right now. And, I think everyone needs to step back a little bit and get ready to embrace some of these additional clauses so we can move forward with some of these transactions. There's still a lot of opportunity out there, and I think it's just bracing for some of the certain sort of terms changing within the multifamily contracts now. As I said, I wrote an article earlier this week that I was going to post after this, really about the different terms and clauses of the multifamily contract that are now reappearing. I had basically about 6 different issues that I'd like to discuss that kind of started reappearing and started being negotiating. Probably the number one for sure are the first thing that just comes up immediately because of this pandemic has just been, hey, I'm a buyer and I don't have time to either get out to the property, or getting out to the property is now more difficult. It's just going to take some more time. And now the conversation starts with the seller about an extension of the due diligence period. So the due diligence period is being brought up at the forefront of every multifamily and residential contract right now in order to have actual time to research the property and inspect the property, and obtaining other third-party reports just takes time right now. With that, sellers understand what's happening typically. They understand that, there are delays now because of the environment, and typically pretty flexible, even though they want to close as quickly as possible. Buyers also want to close as quickly as possible right now because it's an ever-changing environment. With that said, I still get sellers that I think in order to help the buyers, they're willing to give that additional time. Usually now I'm seeing 60 to 90-day extensions in reviewing the property, but I think a lot of sellers still want to see an additional non-refundable, maybe refundable earnest money, but also could be tied to further contingencies such as financing, reporting, and if at all, other material adverse conditions to the market. The second thing that I keep seeing right now is, the second biggest one is the financing contingency. Buyers are struggling right now with trying to obtain some sort of acceptable financing terms. May not be as good as they were before, but there's a little bit of confusion in the market just because lenders are still trying to understand exactly what all is going on, what their investors, such as Fannie Mae and Freddie Mac, need in additional underwriting requirements. Like Shamir said earlier, the additional money for interest reserves is a big thing right now. I just closed a deal about 2 weeks ago that, we went from no interest reserves required by the lender to all of a sudden 12 months.
That was P&I. That was principal and interest.
Right, correct.
That was
And
P&I, so that's a lot more than just interest.
it was a big deal. We were at the end of the deal, but fortunately, the buyers were able to accommodate, and we were able to successfully close that transaction for a Fannie Mae deal. Shortly thereafter, another deal was getting ready to close, and all of a sudden, the lender or the underwriter is now asking for 18 months reserves. And unfortunately, the buyer we had at that point was just, I think that was just a little much pushing to absorb that additional loan amount, and was going to be a challenge. So we're seeing a lot of that, but more specifically to the contract deal, we're seeing buyers request adamantly that they need to tie the earnest money to the financing contingency, and actually creating a financing contingency going, longer or possibly up till closing. It's not an ideal term for sellers, and sellers are quite reluctant to provide that additional financing unless there's some sort of additional consideration, like additional earnest money that's non-refundable. Again, this is the difficulty we're seeing now, but I think if parties are on board, they understand the status quo of the environment right now. They know that if they want to make this deal done, the seller's going to need additional sort of incentive or consideration in order to proceed, to allow the buyer to sort of exit in the event that financing can't be obtained, or the buyer just won't be able to meet the underwriters or lenders underwriting requirements for the loan. The third thing I really see start coming up that we're kind of implementing into a lot of our contracts is just sort of a state of emergency clause. We've been implementing those just because now the current environment, we want to give the buyers extra time if they need to, that if third-party reports and studies can't be done, that if there is a state of emergency, then they want to have that additional time to review those things and obtain those documents during their due diligence period, and hopefully not affect or delay too long of their due diligence, but still pushing out due diligence where they can have refundable money, earnest money at the end. Sellers are finding this, again, it's still a shock factor for a lot of sellers to see these additional provisions and clauses in the contracts. But in the current market right now, that's what the buyers want in order to proceed with a lot of these loans. Reports are also being brought up as a big issue. Buyers want reports, and lenders want reports. And I think sellers are used to providing these initially, but I think now in this current market, buyers and lenders want to see those reports continually through the contract phase and all the way up until closing. They want to have a clear picture of what the financial position is of the property. What's the cash flow? These are key terms that the lender is going to need to understand in order to underwrite this loan, which ultimately can impact whether or not the borrower is going to be able to do the loan. So reporting has picked up, and we're seeing some also threshold standards by borrowers and lenders, such as at least an 90% occupancy rate in the property. They're also requesting an 85% or so collections. So sellers may brace to see some of these thresholds also being tied to the earnest money as another contingency to the contract, and whether or not even the contract will be viable for these buyers if they don't get these thresholds met. We've added in a couple other items, clauses buyers and sellers may be seeing now. The final two are really time. We're adding additional force majeure language in there to sort of explicitly incorporate this pandemic as a force majeure event. Right now, I know it's highly litigated issue as to whether the standard force majeures in a lot of contracts currently ever met that.
Well, I mean, the question is really whether a force majeure allows you to terminate or whether it just delays those timelines, right? I mean, that's another core issue here is just because you have a pandemic doesn't mean you get out. It means that we hold, the deal is on pause, and that's different from getting out.
And to exactly that point, and I seem to always keep going back to, well, do I get my earnest money back? That's really going to be whether how the contract was written, how the contract was implemented. I've seen contracts where the earnest money is tied to a force majeure event, tied to a financing contingency. So these are all new considerations that buyers should take into consideration and discuss with their attorneys. But again, at the end of the day, it's going to be a balancing act with all these sellers. The final kind of issue that I see reappearing now is just sort of your catch-all material adverse condition. Again, we can see that contracts are adding these, pandemic health crisis issues as sort of an immediate exit for a buyer in the event it happens. I think this is it's a tough one to bite on right now, just because of the environment. But with all these new additional clauses, these are probably items that are probably going to continue on in the market. All of these clauses now, because of the COVID-19 or novel coronavirus, are going to be additional clauses that may continue on for a while and want to implement, because again, we just don't know what the current environment will be in the future. But now, buyers and sellers are going to want to be prepared for that, and so they want to have these certain issues addressed up front in case something else happens like this. So that's basically sort of an article I put together. I'll put it out later today or early next week. But it just gives you a better idea of what buyers and sellers should understand and get used to, what are probably going to be implemented in these contracts going forward in the multifamily world. Not seeing a lot of changes really in the single family resident contracts. Those are pretty much staying the same.
And those deals are still closing too.
Yes, the single family doesn't seem to have been affected as much. And I don't think lender terms and requirements have changed radically in that area either. Yeah. It's really more of these multifamily deals, hotel deals that have been impacted the most here.
Yeah, I mean, let's talk a little bit about hotel practice in terms of what you've seen.
So again, like Shamir was saying earlier, a lot of our hotel deals just kind of dried up that we were working on, and obviously hotel owners and sellers are struggling right now because of current rentals, and so the deals that we've seen have really gone away right now, and buyers are really struggling to even comprehend how they can get a loan right now with no income coming in the door. It's just not even feasible right now, and hopefully that with this influx of the new cash from the government will sort of alleviate that and start pushing forward with new contracts. But right now we haven't seen any new contracts come to us or really even be able to salvage some of the current ones. It's been a struggle, especially lending wise on the hotel side. But hopefully that'll change shortly here.
Yeah, hotel seems to be getting hit the hardest.
Oh, yes.
The numbers are just outstanding. Astounding. I think we've had deals that have dropped to 10 to 15% occupancy from 80 to 90. They're just completely shut down, and hotels are going to come out of this the worst, it seems like. Okay, so I'm going to jump back in. There are a couple of things I want to talk about on my end. So on the multifamily side, kind of what's going on and how people are reacting. And then what does the CARES Act and kind of utilizing CARES Act, PPP, EIDL, and some of those items to help mitigate some of the risk or mitigate some of the harm on the real estate side. So multifamily, there are two big issues that are a function or that are a result of the CARES Act. The first big issue is the moratorium on evictions. It's a 120-day moratorium that goes through July 25th. That basically means that if you have a Fannie Mae loan, which a lot of these multifamily deals are, you are not allowed to evict your tenants. And the necessary corollary of that is your tenants know you can't evict them, so they're like, well, shit, I mean, we won't pay. And so you lose a lot of leverage, obviously, in making sure that the economics of the property are on track. So what are we doing there? Well, number one, just because you can't evict, that doesn't mean the rent is not due. The rent continues to accrue, late fees continue to accrue. The ability to evict has already started as of the non-payment and the delinquency, right? So tenants, you've got to make sure that your tenants understand, or that the tenants of a multi-family property understand that the failure or the inability to evict does not mitigate or remove their rental obligation. And that's kind of a core piece to this. The secondary piece to that is, if I'm the owner and I want to help mitigate some of that delinquency, you take a hands-on approach with your tenants. You help them find temporary employment, whether it's Amazon or delivering pizzas for Domino's, or Instacart, or DoorDash, or whatever it is. I mean, there are alternatives out there. There are people seeking to hire in a market that is a employer, where employers are firing people. I mean, the weird thing is, as much as the coronavirus has kind of crushed retail, it's also opened up these other avenues in terms of DoorDash delivery, being more creative on how you operate, drive and pick up, and some of these other things that we hadn't really used much before, and it's forcing people to be more innovative. So I think that just like everything else, people adjust, and businesses are going to adjust, and in order to adjust, they're going to need more people. So I think that we'll be able to mitigate some of this unemployment over a period. The other big thing is, for our Fannie Mae borrowers, there is a program that's kind of codified by the CARES Act, but generally exists, called pursuant to Fannie Mae's regulatory power, where Fannie Mae is undertaking what we call a forbearance. That means that you don't make payments for a period of 3 months on your loan. And the idea is, since your tenants are not making payments, you don't need to make payments as the owner. The forbearance is an interesting item, because it sounds great, like, hey, I don't need to make payments for 3 months, but it comes with just a ton of strings attached. Fannie's requiring monthly reporting. They're requiring what we call essentially like a sweep, where all the money, all the net income, because none of it can be distributed to shareholders or to employers or to sponsors. It all has got to go back to Fannie in order to pay off this forbeared rent. And the way this is supposed to work is, the 3 months of forbeared loan payment are supposed to go and pay. Are supposed to be divided over the following 12 months after the forbearance period's over. So, if they forbear April, May, and June, commencing July, you've now got additional loan payments you're gonna have to make to cover that forbearance period. Essentially, it's 1 and a third payment, right?
Right. Yeah.
So that's a big issue. As part of that, also, Fannie Mae is requiring you cannot evict until the forbearance has been repaid. So that could literally mean you cannot evict for 12 months, which is obviously a big deal. Well, actually, through the forbearance expiration period. So the forbearance expiration date is 3 months. So it'll be you cannot evict during that 3-month period. Like I mentioned, all the money, all this essentially a sweep back to Fannie Mae. And we're seeing kind of similar programs on some of our other lenders. So CMBS, which is commercial mortgage-backed security lenders, which lend a lot in the hotel space, are enacting kind of their own private little forbearance program. But essentially that is 90 days of forbearance, and then those 3 months of loan payments become payable over, depending on who your lender is, the next 3 months or the next 12 months. So you're making double mortgage payments for 3 months. That's just as bad as making payments when you're not making any money. So that's problematic and something that we've seen some of.
It sounds good up front.
Yeah, it sounds great up front. Yeah, I can hold on to my deal for 3 more months.
Borrowers need to be aware that, this money is going to come back around. Those lenders,
Yeah, it's not free money.
right.
It's not free money.
It's not a forgiveness program like some of the government PPP programs or EIDL.
Yeah.
So, I mean, you got to be ready for that shock factor that it may be a while till have any excess cash right now because of those double.
Yeah, and I don't want to steal Christian and Basil's thunder because they're going next and they're going to talk about the PPP and EIDL programs. But on the hotel and multifamily side, and even to some extent on the single family side, EIDL and PPP have some applicability. So just to kind of give a really high level overview, and I don't want to steal these guys' thunder. The PPP is a payroll protection program. It is a loan from the SBA on a 2-year term with 1% interest in the principal amount equal to 2.5 months of your average payroll for the prior 12 months. So essentially 2.5x your average payroll. You get the money up front. And you can use it for payroll or a handful of other approved expenses, including interest and rent. Once you use the money, if you provide adequate evidence of proper use, there is a forgiveness. You've got to use the money, I think, within a certain time period, 80 days. There is a forgiveness by the government where they'll say, okay, look, since you use this to help for a proper purpose, you don't have to pay it back. The challenge there is for our single family and for our multifamily clients, single family rental entities don't have employees. They have independent contractors, and multifamily deals actually don't have employees either because the employees are employees of the property manager. They're not employees of the real estate entity. So the applicability of the PPP is extremely limited. We've seen it some in the multifamily space, but it's going through the property manager. So you have a third-party property manager. They're going to apply for the payroll protection program, and to the extent that they generate proceeds, they'll then use those on your account to pay your employees that are at your property. So we're seeing some of that, and that's not a bad use of the program. I think administratively, it's a freaking disaster in terms of how you work through that with your management companies. But we are seeing some of that. I think we can have a similar problem on the hotel side too, where your employees are employees of your management company rather than employees of the actual hotel. And I think there's going to have to be a similar function where the management company is going to have to apply. The big problem is the limitation on the number of employees. So the guys will talk about how there are a couple of different methods by which you can be phased out for being too large from the payroll protection program, and I think some of the management companies, especially on the hotel side, are going to be too large to be able to apply for PPP on behalf of their client properties. So that's kind of the payroll protection program. The other piece of this is what we call the EIDL, that's economic injury disaster loan. EIDL, that's a function of your income, and it's a more traditional program that's you apply directly to the SBA rather than the PPP, which has a bank-driven, what we call a delegated underwriting process. In EIDL, you apply directly to the SBA, and they go through the underwriting piece. EIDL is unsecured up to $250K, and then it's secured after that, so with guarantees, etc.
So like you said, I think there's really 3 options here, or a couple that you could actually do at one point, but right now, you know, I think right now we were kind of discussing was that probably the more attractive process would be to apply for those PPP loans or the EIDL loan.
Yeah.
We think that really the forbearance program is probably your last,
The worst idea.
yeah, it's going to be your last option here, just because of all the restrictive terms and the management. I mean, having to be without any additional cash flow, because all that's going to be given for the money that you obtained, that you're forbearing right now. It's all going to go back to your lender or servicer. So really, the forbearance is, I think, something you want to hold off on to as your last option here, but really apply for those other 2 loan programs and see if you could push through with just those right now.
Yeah, the challenge on the multi side is, you know, you don't have employees on our real estate deals. We just don't have employees. Like, it's not like any of our guys are directly employing. I mean, sure, some of our smaller hotel clients are, you know, or Motel 6s, Super 8s, whatever. But when we get into, you know, 150 room, 200 room courtyards, they're third party managed, with the employees being third party employees. And when the payroll protection program was drafted, there's an exception from what we call the affiliation rules for hotels under Section 72 of the NACIS code. So, you know, the way this works, or supposed to work, is when you're a single borrower, what they do is they take all the businesses you own. So if I own, you know, 7 LLCs, and every one of them has its own business. Say it's, you know, one's a dry cleaner, the other one's a grocery store, the other one is, you know, whatever. They're going to combine all of those to see if you hit the 500 employee, or the max, depending on your NACIS code employee. There's a carve out from that, and Section 72 deals with restaurants and hotels, entertainment. So with that, they don't use that same cap. There's no cap on the number of employees you can have. And so that's at 72, but that's the hotel. And the challenge with larger hotel properties is that the employees are not at the hotel level, they're at the manager level, and the manager doesn't fall under 72. The property manager actually falls under a different NACIS code. So what was designed to be a carve out for the hotel industry actually doesn't truly work. It works better for restaurants, where if you own, you know, if I own 50 Burger Kings or 75 Pizza Huts, then I have the benefit of, like, not being subject to the affiliation rules, and so the payroll protection program is still on the table. I'm not what we call sized out of that program. So yeah, I don't think Congress truly thought it through. They're still in what they call a rulemaking phase, which means they're still trying to create kind of, we're playing a sport, we're playing basketball and creating the 3-point line at the same time, right? So, you know, the rules of the game keep changing, and what they're trying to do is, you know, build rules to account for the intended purpose, which is to get everybody the upside of keeping their employees and preventing companies from shutting down, and commerce generally from shutting down. There's one more piece to this, which I think probably you hear a lot from the My Tax Filer guys when they did their deal on Wednesday, and there's a payroll tax credit for 2 quarters. I think it caps out at 5,000 or 10,000. I'm gonna double check. But the payroll tax credit is something that may be relevant for companies that are either sized out or otherwise ineligible, or PPP may not be the best option. So that's another piece to it.
I wanted to touch back, probably just also going back to touching on the PPP program and the EIDL program. Just wanted to touch back on some of the loan documents that you have with your current mortgage as a borrower right now. Diving into the loan documents, and this specifically was kind of the generic Fannie Mae non-recourse multifamily loan and security agreement.
Jonathan, can we hold for just a second? We have a question here. If you are a landlord and your tenant cannot pay their rent due to the loss of employment or a percentage reduction in pay, like a furlough, can you apply to EIDL to cover your losses? This is for single family rentals.
I think that's kind of the intended purpose, the intended function of EIDL, and I think this also applies to like Airbnb owners and some of those things, is to help offset that income loss that's a result of the disaster. Now, there's two elements to this. Okay, so you have your expense side and you have your income side, and typically there's a margin in between. From my understanding of the disaster loan on the real estate, in a real estate transaction, it's designed to cover your expense side, so not to cover your profit. You know, so if your mortgage payment's $2,000 and your ancillary expenses are $1,000 and your rent is $4,000, your expense side is $3,000, your income side is $4,000. They're gonna the EIDL is gonna cover you up to the $3,000. It's not gonna give you that $4,000.
Got it. Sorry, Jonathan.
And again, Basil, I know Basil and Christian are going to talk about that.
They're going to
afterwards.
the next presenters will elaborate a little bit more and provide some more clarity on that. But finally, I just kind of wanted to touch back on, I know it's promoting kind of applying for those two governmental programs. And I was also diving into the Fannie Mae loan documents to see where, how does this impact you as a borrower with a first mortgage on the loan, on the property. From what I'm finding, really any default here would sort of be classified under the borrower single asset status of the property. And this is basically a prohibition by the lender or the servicer to no additional financing or indentures or other mortgages are permitted on the property. Now, with that said, the way that I'm reading this is it says that there is no material financial obligation. I think with the PPP program here, because of how it's set up and it's forgiven over time, that this wouldn't really classify as a material financial obligation in this section of the loan agreement for your loan. And should therefore not be a violation. As for the EIDL program, my understanding is that apart from the first $10,000 that may be forgiven over time, any additional money of the EIDL program will need to be paid over the life of the loan. And therefore, this could trigger sort of a default or a breach in your loan agreement. With that said, I know everyone's trying to work as quickly as possible to figure out, what I can do, whether or not this is truly the lender's going to call me at default here. And so I highly encourage everyone, all borrowers with mortgages on their properties, to first and foremost always contact their lender, their servicer, figure out what their position is on this stuff, talk with them about what are your options here, and I think they'll be more than agreeable to figure out what's an accommodable position going forward. I highly doubt there's going to be any lenders or servicers calling loans due at this point, or citing a breach here because you were able to obtain this additional financing for cash flow. As long as lenders are getting paid and you're getting money from that program to pay the lender or the servicer with that mortgage amount, they're usually pretty happy. So I highly doubt they're going to cause any default or disruption with your mortgage as long as you use that money responsibly and being transparent with your lender or servicer about what you're doing with payments and how payments are going to be made going forward.
Yeah, I mean, I think a lot of, like, especially on the single family side, I think on the single family side, there's going to be, a lot of lenders have been pretty accommodating. They have been pretty accommodating in terms of how they account for that. Yeah, so that, I think again, these guys, Basil and Christian, will give you more in terms of like PPP versus EIDL, the very, very specifics. EIDL does require you've been affected by COVID-19, but I don't know if that's truly defined. So I know that question about rental income, that may be, you may have to demonstrate a nexus between between COVID-19 and the non-payment, thus the loss, and they've got to be tied together, right? You can't just be, I have an empty property. It's, it was empty in the first place, and then COVID-19 hit, and now I want to rely on that to generate, to help me offset my expenses. Any other questions, Neil?
I think we're good for right now. Do we want to take a quick break before we hit the noon webinar?
Yeah, let's do that. So let's take a quick kind of little recess. I know Christian and Basil will jump on. They're going to be doing the noon webinar on PPP, and I know Basil has slides too.
So we will take a quick break all, and we will be back in about, we'll start a little bit sooner, just to, respect everybody's time. So we'll start back right at noon.
Yep.
And we'll have Christian and Basil on to go through the PPP program, the Paycheck Protection Program, and the Economic Injury Disaster Loan Program. So both of those will be covered at noon. So get your questions ready. If you already have questions, you can go ahead and type them into the Q&A box, and we will get started at noon. Thank you so much, everybody.
All right, perfect. Cool. Thanks.
Christian, are you ready?
Yes, I am. How are you doing?
Good, good. Well, let's go ahead and get started. We've got Christian and Basil here, who are going to be talking about the differences between the Paycheck Protection Program and the Economic Injury Disaster Loan Assistance Program. So Christian and Basil are both with the Patel Law Group. They're both attorneys. And I will let you take it away from here. Thanks, Christian.
Thank you. Basil, are you on?
Yeah, I'm on.
Okay, perfect. One second, I'm just going to throw the slides up. All right. So as Rachel said, Basil and I are attorneys at the Patel Law Group, both work on our transactional team. Today we'll be discussing the SBA's Payroll Protection Program and the Economic Injury Disaster Loan. I went to the University of Oklahoma College of Law and OU as well for undergrad. Basil, you want to go ahead and introduce yourself as well?
Sure. I went to George Washington University Law School and the University of Texas at Dallas for undergrad. And I do real estate and business transactions work here at Patel, as well as some local government work as well.
All right. Well, we're going to get started with the Paycheck Protection Program. And I'm going to give you kind of an overview and then go into any specific questions that may be had. So it goes by the PPP. What is the PPP? The PPP is a low interest forgivable loan. It's for small businesses to maintain payroll. The principal purpose of the PPP allows employers to maintain liquidity to pay employees for 8 weeks. And the eligibility for the PPP or for small businesses, as Shamir and Jonathan kind of stated, just a little repeat on that. Is for small businesses with less than 500 employees, unless they're under the NAICS code 72. And then there is a waiver for the affiliation rules for certain businesses. Those businesses are specifically ones in the hotel and food and services sector. And then anyone determined to franchise in the SBA's franchise directory. Also, small business or an eligible business would be one receiving financial assistance from small business investment companies licensed by the SBA. Also, sole proprietors, self-employed, and independent contractors are eligible, and nonprofits, veteran organizations, and tribal businesses. And if anyone has any questions, feel free to drop them in anytime, and we're happy to answer as they come in. Under the NAICS code 72, it's easier if we just kind of put in the list. It includes hotels, casinos, bed and breakfasts, RV places, rooming and boarding houses, dormitories, and then in the food and service sector, there's a comprehensive list including food and service contractors, caterers, mobile food services, and then drinking places with alcoholic beverages, full service restaurants, limited services restaurants, cafeteria, buffets, snacks and non-alcoholic beverage bars. And more on the PPP, people are always wondering what are the specific terms. The loan amount is 2.5 times the monthly payroll. And then if there is an outstanding EIDL loan, EIDL is the economic injury disaster loan that Basil will discuss shortly. If there's an outstanding balance that was funded before April 3rd, that will go into your PPP loan application. So the 2.5 times your average payroll is your typical principal amount. And then if there was an EIDL loan that was funded before April 3rd, that'll count in. We don't know of many clients that did receive their EIDL loan before April 3rd. The maximum loan amount is $10 million with an interest rate of 1%, and the term is 2 years. There's no there's no prepayment penalty on here, and then the payments are deferred for 6 months. So we've had a lot of questions about what is average monthly payroll. So average monthly payroll includes your salaries, wages, commissions, any compensation to employees, including cash tips, payments for vacation, parental leaves, family leaves, medical leaves, or any sick leave. And it includes an allowance for separation or dismissal and all employee benefit, including taxes that state and local taxes are paid. And continuing on that, for most business owners, the average monthly payroll will just be easy calculation of your 2019 average payroll. So you're going to go to whoever your payment processor is, figure out, get your annual payroll for last year divided by 12, a simple calculation. You're going to put that number in the box. We'll have a times 2.5, enter that in, and that'll be your typical loan amount. For certain businesses that have like a spring or summer seasonal influx of revenue, or even just a high busy season, the revenue will be calculated based on your average. Your payroll will be calculated based on your average payroll from February 15th, 2019 through June 30th, 2019. And then we have several clients who've opened new businesses this year, and so to calculate their average monthly payroll, your new businesses will be from January 1st, 2020 through February 29th. So we're going to take what your payroll between the months of January and February, divide that by 2, and that'll be used for your amount before the multiplier. And then just a note, there is a $100,000 cap per employee. So if you have any employees that went over the over the $100,000 amount for 2019, or for whichever period is being used for calculating the PPP, that those employees will be brought down. So if they're making 150,000 last year, you're going to take them down to 100,000 before calculating your PPP amount. And Basil, feel free to jump in anytime. Waivers. So typically on SBA debt, there's a credit elsewhere requirement test, which just looks into where else a borrower can find capital. They're waiving that test. They're also waiving the personal guarantee requirements and the collateral requirements for the and the permitted uses of the PPP loan. Its intended purpose is to primarily be used for payroll. And so it's payroll, including benefits. It can also be applied to mortgage interest as long as the loan was taken before February 15th, 2020. Can be used towards rent, but the lease must have been in effect before February 15th, 2020. And then utilities, and also the utilities, the service just must have been set up before February 15th. And the biggest question that we're getting on the PPP is the forgiveness portion of this. So the entire PPP amount that you receive is forgivable, which will be processed through your lender. So the first thing that must be done is you go ahead and request the lender's requirements to process your PPP forgiveness. So you're going to have to provide that the proof that the funds were used for their intended purpose within the 8-week period of receiving your loan funds. You're going to have to prove that you retained the same number of full-time employees that you had last year or prior to taking the PPP, or sorry, prior to the coronavirus pandemic. And then if for some reason you're not able to bring on the same amount of full-time employees, the forgivable amount is proportionally decreased by the number of full-time employees that you have brought on. And one thing to note, that to maximize your forgivable amount, 75% or more of PPP funds must be used towards payroll. And then the other 25% can be forgivable if it's spent on the other 3 buckets, which are mortgage interest, rent, or utilities. And some miscellaneous things on the PPP. The forgiven amount is not repaid. One other thing that is helpful is that the forgivable amount is not taxable. So it's not going to be taxable income for your 2020 tax year. The application must include ownership information for anyone owning 20% of the business or more. And then the applicant must not be in default on another SBA loan. The principal place of residence for all employees must be in the United States. And an applicant cannot obtain both a PPP loan and an EIDL for the same cost. So if you're taking both loans, you're going to want to use your PPP funds primarily towards payroll, and then the other 3 buckets before you're using funds for the same purposes. And if you've received an EIDL loan already before applying for your PPP before April 3rd, then those funds will be processed into your PPP application and then refinanced. The application link is attached here. You can click on the link, fill out the application, and the application will be processed through your local lender. And if there's any questions, feel free to drop them in anytime. Basil's going to go ahead and go over the economic injury disaster loan, and we're happy to answer any questions.
Can y'all just
Hey,
get a
everybody.
little bit closer to the mic?
Hey, everybody. Can you hear me?
Oh yeah, that's much better. Thank you.
Awesome, of course. So I'll be covering the economic injury disaster loans program, and the way you could sort of distinguish between the 2 programs is that the EIDL program is really intended to be a loan program for people who have suffered sort of a much more specific, substantial injury as a result of the pandemic, and it gives them a loan funds that they can use for a wider variety of purposes than the funds they would receive from the PPP program. Kishan, could you move me to the next slide? Okay, so the basic provisions of the EIDL program is it gives you a low interest, non-forgivable loan, and it gives it to small businesses that are specifically injured by a disaster. In this case, the public health disaster of the COVID-19 pandemic, and it gives the small business these funds with relatively wide latitude in what they can use those funds for, with the intention that the loan will carry the small business until it can resume normal operations. Next slide. So who is eligible for the EIDL loans? First, you have to be a small business. You have to have less than 500 employees, or if you have more than 500 employees, you could check the SBA's standards for specific industries. And sometimes the SBA might have a higher cap, but generally you're going to have less than 500 employees. For the EIDL program, there's no waiver of the affiliation rules. So you still have to consider the business that's applying for the loan in its entirety. It's not split down to its physical locations, or any other kind of waiver of the affiliation rules. Like with the PPP, however, sole proprietors and independent contractors are eligible for EIDLs, and so there's that expanded eligibility there. If you're a small business, you also have to have suffered a substantial economic injury caused by COVID-19. Now, substantial economic injury, and I know this question came up when Shamir was on, and it's a little bit, it's quite a bit more restrictive than just saying that I have tenants who lost their jobs because of COVID-19, and therefore my revenue is somewhat less than it was before. You really have to show that you've sustained such an economic injury, such a loss of revenue, that you can't meet your obligations that are coming due. So like you can't meet your loan payments, you can't meet your rent payments, and so forth. Or you have to show that you've sustained such a loss that you can't pay your ordinary and necessary operating expenses. Loss of anticipated profits or reduced revenue by themselves are not substantial economic injuries. And I'm happy to answer sort of more specific questions about that as we move forward. The two last requirements for eligibility for an EIDL are that you have to have been in operation as of January 31st, 2020. If you're applying for an EIDL, particularly in connection with COVID-19. If there's another disaster, it's a separate question. And you can't have any federal tax liens, so that has to be clear before you apply for the EIDL. So when you apply, what are the loan terms? The maximum amount of the EIDL loan is generally $2 million. So it's less than the Paycheck Protection Program. There's a small exception for businesses that are large employment centers compared to their community. So if you employ a really substantial number of people compared to your community, you may be eligible for a higher maximum. So you might want to talk to your accountant and lawyer about that if you think you might be eligible. However, that's just the maximum. The actual amount of your economic injury loan will be limited to the value of the economic injury as determined by the SBA. So the SBA will look at what have you sustained in terms of injury, what has been your revenue loss, what have been your expenses, and will determine the scope, the actual amount of the loan based on that. Once you get the loan, the maximum interest rate will be 3.75%, but it could be lower depending on your credit worthiness. The term of the loan will be up to 30 years, but it could be shorter. Again, this depends on your credit worthiness. There is no prepayment penalty, again, just like the PPP. But in the case of the EIDL, the payments are deferred for 1 year instead of 6 months. And of course, this is sort of, again, emphasizing the point that EIDLs are for businesses that have sustained sort of a higher level of injury than your run-of-the-mill business. So there's a few waivers that make it easier to get the EIDL loan for in connection with COVID-19. First, you have the credit elsewhere requirement being waived. So your typical requirement for SBA loans that you show that you can't access credit anywhere else. That requirement has been waived, so you can just go directly to any EIDL. For loans that are less than $200,000, also the personal guarantee requirement is waived. So the loan, can be, to your entity, to your special purpose entity, and not have a personal guarantee. Your collateral requirements are waived for loans that are truly small, $25,000 or less. But for loans that are larger than $25,000, you can make the collateral your business assets instead of any of your real property, which is somewhat more advantageous than the usual. Finally, to speed up the process of approving these loans, the CARES Act provided that the SBA can approve borrowers for EIDL based just on their credit score, and they don't have to evaluate your tax return and things of that nature. So those are the waivers. So now we get to the permitted uses, and I know I mentioned earlier that the EIDL can be used for a wider range of purposes and uses than the PPP, and this is what I was talking about. The primary, expansion of uses for EIDL is that you can use it as working capital. So your general expenses that you incur in running your business, you can use your EIDL towards those. You can also use it towards remediating, the disaster. Obviously, this comes more into play when we're talking about a tornado that, destroyed your building or things of that nature. But here that's not as big an issue. You can also use the EIDL for obligations that are unmet due to revenue loss. So if you lose a lot of revenue, you're a hotel, and your income, your revenue has gone down significantly, and you're having trouble meeting certain obligations to your lenders and so forth, your EIDL can be used toward that. And finally, if you're having problems, sourcing inventory or other supply chain problems that raise your costs on the supply chain, you can use your EIDL to cover those costs. And all of that, of course, is in addition to things like payroll, rent and mortgage, and paid sick leave. So it's a broader range of uses, and the intended purpose is to help someone who's a business that's gone through a substantial injury recover from it. Now, there are prohibited uses, and violating those prohibited uses can result in significant consequences in terms of liability. So it's good to be mindful of what those prohibited uses are and to avoid them if you ever get an EIDL. Repairing physical damage is a prohibited use. And I mentioned doing something like repairing your building after a tornado, but you wouldn't really be able to do that. Refinancing pre-disaster debt, that's not an EIDL use. You can use the EIDL to make those payments on a mortgage or on debt, but you can't refinance using EIDL. You can't use EIDL to make payments to other federal agencies. If you have loans from any other federal agency, whether it's USDA or what have you, you can't use it to pay tax penalties, and this is probably more important, you can't use it for dividends or other disbursements to the owners of the business. Now, there is an exception to that rule, which is that if you can show that the disbursement from the EIDL to an owner was for services performed by that owner for the company or for the business, that's fine. And you should work with your accountant on that to determine sort of what is a reasonable salary that you can take based on the work that you're doing for your business. And it's that amount that could be taken as compensation from the EIDL. Now, in this specific emergency that we're having, Congress authorized folks who apply for the EIDL to be eligible for emergency grants. Now, these are grants; they're not loans. So if you do get them, you have no obligation to repay them, even if you're subsequently denied for an actual EIDL loan. These grants are maximum up to $10,000. They're intended to be sort of a stopgap measure for businesses that are truly in crisis. But you have to have employees in order to get any of this grant money. You get $1,000 per employee. And so if you have less than 10 employees, you're not going to get the full $10,000. Now, when you apply for these grants, and the application for them is the same, you do it at the same time as you apply for the EIDL itself. The issuance of the grant is discretionary with the SBA. So they're supposed to give you an answer within 3 days, but they will evaluate whether you meet the criteria, whether you really need this grant, and so forth, and make a determination. Once you get the grant, the same use restrictions apply to the grant as they apply to a regular EIDL loan. So you can still use that grant for a broader range of purposes than your PPP loan, but you don't have to pay it back like you do with an EIDL. Okay, so we're getting to the end here. A couple miscellaneous points. The first is that an applicant, as Christian already mentioned, an applicant can't obtain both a PPP loan and an EIDL loan for payment of the same costs. So just make sure to segregate your costs, use the PPP for its intended purpose, for the allowable expenses there, and then use the EIDL for your other costs that are not allowed under the PPP. If you want to make use of this program, and especially considering the special terms and the waivers that we've discussed that have been made available in connection with COVID-19, you need to do it by December 31st, 2020. And you can access the application. I believe we put the link on the next slide on the SBA's website. And you can apply directly to the SBA. You don't have to go through a lender. Just go to that link and fill the application.
And the idle application is really simple. It should take 10 to 15 minutes. You just want to make sure you have your gross receipts, your cost of goods sold, if applicable, for your business, along with your business information. It's a really simple application, and you just want to make sure you check the box for the $10,000 advancement on, I believe it's step 3 of 4.
Sounds good. Do we have any outstanding questions?
It looks like we have one question here. For the emergency grant, will we hear from the SBA on whether the answer is yes or no, or will we only hear yes? And how long is it taking people to get answers? So this is on the EIDL
So I believe you should hear either way, yes or no, and you should hear within 3 days. I'm not sure exactly how long it's taking
So
the
we are
determinations to come in right now.
We're speaking to many clients and family friends who've applied. I have actually not heard of anyone that has heard back on whether they're receiving the EIDL grant or not. So I think it was a good goal for them to say that the funds would be dispersed within 3 days. I think once the number of applications started coming in, the SBA quickly realized that it wasn't able to process the applications quick enough. So we still are recommending our clients fill it out, but we don't have an answer yet as to how quickly those funds will actually be dispersed in regards to the advancement.
Yeah.
Great. So I don't think we have any other questions at this time. No, we do have one more, I'm sorry. Similar question to that asked about PPP for the EIDL. If you're self-employed, but you have no payroll, can you use the Schedule C to determine the salary amount for the emergency grant?
So you can't apply only for the emergency grant. You're applying for the EIDL loan, which will be based off the gross receipts and the expenses that you put in your application. And a part of the loan amount that they would give would be a $10,000 advancement. It just happens to be that that $10,000 advancement does not have to be repaid. So there's not an amount just to go in for the emergency grant. But yeah, in filling out your application, you Schedule C to determine the salary.
Okay. One more question here. We have a loan number for the EIDL. Should we reapply?
You have a loan number for the EIDL. Could you clarify, do you have when you applied for the EIDL and received your confirmation number, is that what that is?
Well, let me see if we can get some clarity here. Yes, the answer to that is.
Okay. Did you apply after, did you apply in the new process that was just the short 10-minute application, or was it the original process that you had to log in and create a username? If you applied and were able to see information about the $10,000 grant, then you don't need to reapply. But if it was before that and you applied where you had to drop in all of your personal financial statements and business documents, then yes, you would need to reapply.
Any other questions?
You applied before. Okay, yeah, you would want to go ahead and apply on the link that's on the screen. The current application for the EIDL is very quick and shouldn't take near as long as before. I think most clients are able to knock it out in 10 to 15 minutes.
Great. Well, it doesn't look like we have any additional questions at this time. Christian, what is a good email for people to reach you at if they have questions, either to you or Basil?
Absolutely. If there's any questions regarding anything discussed today, I can be reached at kpatel, P-A-T-E-L, at patellegal.com, and Basil can be reached at bmusharbash at patellegal.com, and I can share those I'm not sure if it's showing.
There it is.
Okay, yeah. So, but feel free to contact us with any questions. We're happy to answer anything we can, and if there's anything needing further discussion, we could set up a call or something.
Great. Well, I want to thank you guys so much, the Patel Law Group, for taking time out of this very busy time period to join the U.S. India Chamber and our members and our partners in answering all of these incredible questions about the process. We've got a comment here that said, "Thank you, this was very helpful." Thank you for that note. We appreciate everything. And again, if you would like to listen to any portion of this program, again, we will be posting the recording to our YouTube channel at USICOC DFW. You can also find a link to it in our Chamber's newsletter that'll be coming out on Monday or Tuesday of next week. You can subscribe to that newsletter at www.usicoc.org. And if there is anything that we can answer for you through the Chamber, if there are any topics you would like for us to host a webinar on, please reach out to us. You can find me at president@usicoc.org, or you can find my colleague at info@usicoc.org. Either way, we can get those requests fielded. And if we can host a webinar on a topic that's important to you, we would be happy to do that. So thank you so much for joining us. Thank you all. Stay safe and have a great weekend.
Thank you for having us.